Okay, great. All right. Once again, my name is Zoe Dolan. I am the supervising attorney at Public Counsel, responsible for running our appellate clinic. It's at the court, Second District in the Ronald Reagan Courthouse. And essentially, our goal is to help self-represented litigants, such as yourself, get from step one, which is a notice of appeal, to step final, which is a reasoned decision, hopefully, on the merits at the appellate stage. So we're just going to be talking about that process today and not anything in the trial court. We're going to assume that there's already, a judgment or some sort of decision at the trial court level that you're challenging.
Can you get a copy of this for you?
No, but it will be made available on our website.
Oh, okay.
Yeah, and I'm going to show you our website with all of those tools as well.
Thank you.
Okay. Let's hold all questions to the end if we can. Okay, so the first tool that I want to let you guys know about is this website. selfhelpappellate.courts.ca.gov appeals timeline. Sorry about that. And this is a helpful website. I'm going to show you a few different websites. I don't have a PowerPoint presentation because I want to show you stuff that you can actually use. Okay, so I'm going to show you the websites. We're going to be working from those. And this is a good place to start because it basically, walks you through every step that we're going to be talking about. Okay. So it's a good reference to have, and our website breaks it down. Before we get to our, specific materials and all of that, let's just talk about what's here on the website. Okay, so step one is the appealable order, right? And then if you see sort of down toward the end, we go through step 9, court opinion, and then some additional things at the end. So the question is, how do we get from step 1 to those other steps? So the sort of main thing to remember in an appeal is that it's very different from the trial court. Okay. In the trial court, you have a complaint, you have all these types of motions. Maybe you have a trial, maybe you have a jury, maybe you have a bench trial, maybe you have a motion to dismiss or a motion for summary judgment. All these, you have discovery, you have all these different types of things. And, things generally happen in an orderly fashion, or at least you can kind of predict how they're going to go. But appeals are even sort of more predictable in terms of what the steps are. Okay. And there's really only 2 main steps. And those steps are getting the record together and then filing your brief. Okay. So what do I mean by that? What's the record? Well, the record is anything that is in the record in the trial court. So all of the documents that were filed, any orders that the judge issued, any proceedings that were transcribed. You have to ask them to be transcribed. We'll get to that a little bit later. But all of the stuff that happened in the trial court, okay, that you want to be part of your record on appeal that you're going to talk about in your case. Okay, so let me ask you, do you need everything that's in the record on appeal? Do you have to designate everything or maybe only some of it?
Whatever you want.
Whatever you want. Yeah, and we'll get to that. But what I'm saying is it's a little bit different from the trial court. It's like, not a set in stone type of thing. You get to decide, okay, this is what I want in the record and this is what I don't want in the record. But anyway, the first question is, and then after you get through the step 2 of part of the appeal is the opening brief and everything that follows after that up to oral argument. So unlike the trial court, where you have different hearings along the way, in the appellate court, you usually only have one hearing, and that's oral argument at the end, after the record has been assembled, after all the parties have fully briefed the case, and after the court has had a chance to look at all that. So you get really one shot. You don't, get multiple appearances like you're accustomed to in the trial court, where you're going back and things are happening and changing and that type of thing. Okay. So the first is an appealable order. That's sort of step 1, and we have this question a lot in our clinic, and essentially it's let me just ask, what do you guys think? Can you appeal anything the judge does?
Yeah.
Not immediately. Not immediately. There's only certain types of things before final judgment that you can appeal. Generally speaking, it's only a final judgment in a case. So if a judge says, if you say at a trial, objection overruled, can you appeal that? Not immediately. That's part of the record, okay? And you're going to deal with that on appeal once you get a final judgment. But the first question when you even get in the door is this order appealable? Why is that important?
Because the appeals court doesn't have jurisdiction.
Then the appeals court doesn't have jurisdiction, and you will, if your order is not appealable, you will go through however many steps until one of the judges, the justices, or one of the court staff realize, wait a minute, I don't think this is an appealable order, and then you will have spent 6 months or 8 months or whatever it is, and all that time and all that energy, and they say, wait a minute, and they will issue a letter and say, prove to us why this is appealable. We don't think this is appealable. They'll give you a chance, and if they don't agree, then they'll just dismiss the case, and you got to go back, and then you're like, I should have just listened to Zoe at the presentation. Okay. So generally, the thing about appealable orders is it's a little bit of a patience game, and you'll see lawyers, in the movies and stuff. Oh, I'm making the record. I'm doing this. Along the way, you are, recording all of those errors, all of those things that you want to talk about at the appeal, and at the final judgment, you appeal the final judgment. It's like an umbrella. Okay, and under that umbrella, you take along with you everything that was that's inherent in that final judgment. So you can, like, all the, just keep a list, and you're like, the longer my list, in some ways, the better. The more mistakes I see, the better for my appeal. I can't appeal this now. That's frustrating, but I'll do it later at that stage. How does an appeal start? What starts an appeal?
Notice of appeal.
Notice of appeal, 1-page form. It's very simple. The court has it. I'll show you all of that stuff in a second. And, essentially what you're saying in your notice of appeal is, this is the name of my case. This is my name. This is the date of the order that I'm appealing. And this is my signature, proof of service. I'm letting you know that I'm appealing this. Where does the notice of appeal get filed? And generally speaking, when is it due? Does anyone know? Usually 60. There's some exceptions for certain instances, but rather than get into that, let's avoid that and just try to think within 60 days if you can of the final judgment. It needs to be filed within 60 days. And where does it get filed? In the appellate court or the trial court?
Sure.
Trial court. All right. We're holding questions to the end. Okay. So say you have an appealable order, say you have final judgment, say you have filed your notice of appeal within 60 days. What's the next thing that you have to do if we're first in that first step of things, getting the record together? Designating the record. What does designating the record mean?
You're asking the trial court basically to put everything together that you want, I guess. Even transcripts.
It kind of is exactly what it says.
Right.
You designate the record. That's what it is. It's a form, 4-page form, and you say, these are the documents that I want in the appeal, and these are the proceedings that I want transcribed. Okay. The second district, which is where we are here in LA, they don't have, there's in other districts in California, they have a thing where you can just check a box and say, I want the whole record. It's much easier. We don't do that here because we have so many cases and the courts need to be budgetarily and fiscally responsible. So you have to choose which documents you want in your record. Okay.
Or you can do it yourself.
I have a question on that.
We're going to take
Yeah,
questions
we're
at the
taking
end.
questions till the end. We just have another 40-ish minutes to get through the content.
Yeah.
We're learning a lot.
Okay, and then they have additional filings. For example, I'll show you a civil case information statement. There's 1 or 2 other ancillary documents that you have to file as well. If you forget anything, the court lets you know that you have to do it within 15 days or else they're going to dismiss your case, this type of thing. Okay. So this is pretty much what step 1, right? Getting the record together and preparing the case. Go ahead with the brief. So then we get to the second line here. Opening brief. Can anyone tell me what an opening brief is? What's that? Who does that? The appellant or the respondent? And by the way, who is the appellant and who's the respondent?
The appellant is the one that filed the notice of.
Okay, appellant is the one who filed the notice of appeal, who started the appeal. By the way, can the appellant be a plaintiff or a defendant or both?
False.
Either one, right? Whoever lost or whoever's upset, whoever doesn't like what happened, they file a notice of appeal, they become the appellant. And so the appellant, the person who started the appeal, has the opening brief. We'll talk about it and I'll show you templates, but what do you think goes in an opening brief?
Everything you want the justices to see that it was.
Any other suggestions?
It's an introduction for the case.
Oh, it's way more than that. It's
Case.
everything. Kitchen sink goes in the opening brief. If it's not in your opening brief, the justices in the court are not really going to consider the argument. So you need to think, the opening brief, and you can ask for an extension, all different types of things. But the opening brief is where you get one shot to present your initial arguments. Okay? And then what about the respondent's brief? What's that?
Response brief.
That is from the respondent. Opening brief is from the appellant, and the respondent's brief is exactly what it says, right? From the respondent. Okay. So the first that whoever started the appeal gets a chance to say, like, hey, these are all the issues, these are all the facts, this is the part of the record that I want you to look at, and these are all the reasons why I'm right and the court below was wrong, and you should reverse or do whatever I'm asking. Okay. The respondent's brief is where the opponent, your opponent, says, no, that's not cool. The court did the right thing, and here's all the reasons why. Okay, so it's their response. And then what do you think a reply brief is?
Whatever their account has.
Yeah, you get one last chance. The good thing about the appeal is you get to sandwich your opponent's brief with your own. So you get to say in your opening brief, these are all the issues that I see in the appeal. And these are all the reasons why you should reverse or do whatever it is that you're asking for. Your opponent says, no, the arguments are bunk, don't do that. And then in your reply brief, you get to say, actually, here are all the reasons why the respondent's brief is wrong. So you get actually those two bites at the apple. This is the briefing section. So it's like I said at the beginning, right? That's it. There's no more like, oh, I forgot, I want to do a motion, I do this other motion, I'm going to go into the court and I'm going to tell the court, this and that happened, I forgot to include it. That's the last chance. So you want to make sure when you're doing that briefing process, the appeals are a little bit different. Like I said before, you want to make sure when you're doing that briefing process that you have everything in there that you want the judges to consider. And what about oral argument? What happens there? I'll give you a hint. I'll give you a hint. It's 2 words and they are oral argument. It's literally exactly what it sounds like. You get to go up in front of the justices and you have a podium and your opponent has a podium. Each of you has 30 minutes and you get to argue, a little bit more. Okay. And, generally what I used oral argument for when I was more of an actively practicing lawyer, I have a list, I have an outline to say, these are the 3 or 4 things that I think this court must consider, right? So you're like, okay, I've done all my work again in the reply, and now I'm going to go into the court and I'm going to have a list of 3 or 4 things that, if the sky falls otherwise, these are the 3 or 4 things that we need to, really focus on, for this appeal. All right. After that, the court will issue an opinion. Okay. Step 9 is where our clinic uh, finishes its ability to assist in the process, okay? Because we view that as, as the successful completion of the goal that we set out in the beginning, which was to help everybody get from the notice of appeal to the reasoned decision on the merits, okay? After that, there are some other things that you can do. You can ask the court to hear it again. You can try to go up to the California Supreme Court and ask them to hear the case. Our clinic has some materials that if you get to that stage, we can provide you with, but we do not assist past this point, okay? So we try to get you up to the court opinion, and we provide all the legal information and assistance that we can through appointments in person and via Zoom and on our website, which I'm just about to show you, to get you to that point. Okay. If you win, then what happens is the court generally will send the case back to the trial court, maybe with some additional instructions. We think you made a mistake here and you should reconsider this or that. If they affirm, then they say, we're not going to overturn the decision remains in place. Okay, so those are sort of basically the two types of outcomes that you can expect.
Keep it at one time. I'm sorry, I know you're saying about going back to the court.
Generally, appellate courts are a little bit hesitant to completely change something. And generally what they do is they say, if they do reverse, they will say something like, we've found this legal error, we're going to send it back to the court to reconsider in light of the following instructions, and then they will give it the law, okay? Generally, that's what it's not a hard and fast rule, but generally that's what the appellate courts will do, rather than just completely, point blank, just change everything on their own, okay? We're gonna do questions.
Because
You
it's
do
not
not.
legible.
It's right on, you know what, let me make this easier to,
So for those that were late,
It's not about-
there's going to be a video recording available on the public counsel website later. And that is a resource you can take advantage of later.
all right, yeah, and you can also just go to the website right here. Okay.
Thank you.
All right, so let's go to our own resources that are available to the public at any time. This is our website, publiccounsel.org/clinics/appellate-clinic. And if you just navigate on the panel here to forms, guides, and samples, this will take you to our library of resources and materials. Okay. Our library of resources and materials, we have a general information section up at the top. And then look, notice of appeal, fee waivers, civil case information statement, designation of the record, opening brief, oral argument, applications and motions, reply brief. So how is this generally organized? Same way. Yeah, okay. So what we try to do on our website is to give you each chunk of material that you're going to need in the order, generally speaking, that you're going to need it. Okay. Designation of the record technically is due within 15 days of the filing of the notice of appeal, by the way. So that does happen pretty fast. All right. So for each one of our sections, we have a few different things. Let's see. Let me see if I can get you. All right. So this is for the brief, for example. And what I'm clicking on here, let me just show you again. I think this is pretty dope, honestly. Not gonna lie. Is it still loading? All right, well, we'll come back to that. All right, so everything is organized pretty much the same. Up at the top of the section, you have the especially important stuff, and then some general instructions and overviews, and then some additional documents that are relevant to that step, okay? Same thing in record designation. There's an overview of the record designation, some general stuff, and then some specific forms that you'll need. Same thing with opening brief, general important stuff, some overviews, brief template that you can download. It comes as a Microsoft Word document, and you can work with it yourself or feed it into an AI, which I'll be showing in a few minutes. Okay, so this is the AI-generated overview of for the opening brief. Let's see if we can just give you guys a preview.
Ever feel like the deck is stacked against you when it comes to the legal system? Like there's this whole other language you're supposed to speak? Yeah. Well, today we're handing you a secret weapon.
Okay.
The art of crafting a killer opening brief for the Court of Appeal.
It's about leveling the playing field, really.
Yeah.
Giving you the tools to present your case effectively.
And we're doing that with a real life template from the California court system. Think of it as your blueprint for success. But before we jump into the nitty gritty, I'm curious, what's the single biggest misconception people have about these appeals?
You know, a lot of people think it's just a chance to re-argue your case.
Right.
Like you hit the replay button on the trial. But it's not about emotion or simply disagreeing with the outcome. An appeal hinges on demonstrating significant errors in the trial court's application of the law.
Okay.
Errors that directly impacted the final decision.
So it's about strategy and precision.
Absolutely.
Like a surgeon going in with a scalpel, not a slug.
They're not too bad, are they? Our AI friends. Pretty much exactly what I said, right? Point of it is, I know that we all learn differently. We all acquire information differently. Our goal is to make it as accessible as possible to all different types of people. If you're an audio learner, if you're a textual learner, whatever kind of resource you want, we try to do our best. Just to give you another few seconds of the discussion.
What, when, where of your case.
Okay.
You're setting the stage, laying out the events that led to the lawsuit. What's the
That's right.
Absolutely. But remember, this isn't a novel. It's about presenting the facts.
They're talking about the
objectively
opening
and
brief here.
precisely. Right. You'll divide this section into two parts, factual history and procedural history.
Okay, let's break that down. What goes into each part?
Think of factual history as the who, what, when, where of your case.
Okay.
You're setting the stage, laying out the events that led to the lawsuit. Let's say you're dealing with a case like Goldilocks and the Three Bears.
Okay.
In this section, you detail the bears leaving their home, Goldilocks entering, first sampling the porridge,
Yeah.
the whole shebang.
Okay. I'm already seeing how this would play out in a brief. Now, what about the procedural history? Where does that fit in?
This is where you shift from the events themselves to how those events were handled within the legal system.
Okay.
Did the bears file a police report? Was there a hearing?
Right.
How did the trial unfold?
So in Goldilocks' case, we'd outline the charges.
Okay, so I wanted to play this for a couple of different reasons. First of all, just to give you an idea of some of the resources that are available that you can access anytime on your own. But also, what were they talking about in there? Essentially, they were talking about the opening brief, but how were they talking about the opening brief? What were they really referring to when they're talking about the facts and the procedure? What was that referring to?
He says about errors that were made.
Right. So why do you think, if we were talking about the opening brief, why do you think I focused on that section to have you listen to?
Because that's like the.
Because they're talking about the record, right? So what I wanted to show you was how important it is to make sure that you've got that record and you're thinking about, okay, I'm going to tie all of the arguments in my opening brief to the record. That's what they're talking about. So I wanted to give you an idea of how these steps fit together and why these first steps, that step one in particular of getting the record together and setting everything up for your opening brief, why that is so important. Okay. All right. So just to give you a little bit of an idea, here's the sample opening brief from the court. By the way, this is why they talked about the Three Bears and Goldilocks, because this is what I gave the AIs to explain. This is what the court provides as a sample template to work from. You know, it's just very simple, straightforward thing of what you can try to make your brief look like. We have the opening brief template. This one opens as a Microsoft Word document. We also have a simplified version, as you saw on there, but I'm just going to discuss this one. This is the template that we provide you on our website. Just take everything in brackets and put in your own information instead. And then it goes section by section so that you can put together your brief for your case with the factual and procedural background, which the AIs just talked about, and then going up through the legal argument in your case, including the law, which we're going to talk about how to research and find next, in addition to all the tools that you get here at the law library. And then a couple things at the end that we have: certificate of word count, placeholder page. All right. So the one thing I will recommend, since I have everybody here, captive audience, there's a lot of initial pages, and there's like this introduction with a lot of words in it, statement of appealability, all this stuff. What I recommend you do is just start on page 7 with the factual and procedural background. When I was writing appeals on more regular basis myself, that's where I'd start. Because you're like, oh, this stuff's going on with the law that I kind of maybe understand and maybe don't. Then I've got, this introduction. It comes first, but I write it last. And the reason is because if you can get the facts down and if you can get the procedural history down, then the legal argument follows naturally from there. And by the time you're all done with your brief, you go back to your introduction, and the introduction will write itself in like 5 minutes. It will just fall right off the tip of your tongue. But if you're looking at a whole brief that you've never, especially if you've never done one before, and you're trying to think, oh my God, I have to get this introduction perfect, you'll get stuck on that for 2 weeks, 3 weeks on end, and you won't move past it. I'm just taking a guess. That's what happens to me. Am I right? I've seen.
Not be more right.
Okay, forget it. Don't worry about it. You can do.
Where are you?
I know, right? You can do that last. You just start with what you know, which is the facts and what happened in the court, and then you move into your legal argument, and then at the very end, when you're like, I know my case, I know my appeal inside out, I'm going to write my introduction in 5 minutes, right? So it becomes a lot easier. Okay. So where people get hung up is on the legal framework and governing principles of law, standard of review, and things like that. So we're going to talk a little bit about access to justice and artificial intelligence. Okay, before we get into this, it's important to understand that the AIs are getting better and better, and they're getting better and better, faster and faster. And there are more and more tools that are available, and they are of varying degrees of reliability. So the tools that we're going to show you are the ones that tend to be more reliable, but let me just be clear. Can can you accept everything that an AI says?
No.
You cannot. You have to check it. Okay. So I see everyone in here nodded and how many people use generative AI on a regular basis, by the way? Or do we have fairly regular? Y'all weekly, you check in with it? Okay. So we have about 3 or 4 people. Okay. But we all know that they're still learning and we have to verify everything they say, particularly if it's important. Okay, they're not lawyers, which is important because if I give legal advice, my law license is on the line. They don't have law license. Right now, they don't care. If they're right or wrong, they just say stuff. There's different versions, and we'll maybe show 1 or 2 of those if we have time, that have what we call chain of thought. So they check their own answers multiple times. Those are more reliable. But right now, what we're trying to do is just work on knowledge discovery to get, ideas for cases and to get, initial drafts of things that you can then try to verify on your own and incorporate into your brief. Okay, so this one is perplexity.ai. And I'll just give you an example of how we try to utilize these types of things.
Is it an app or just Appellate?
There is an app. There is an app, but we're just going to use the browser. Correct. Okay. So we're doing a couple of different things. That's a little small. Let me see if I can. Everybody see that a little bit better? Okay. So, here's your prompt. Please educate me about the legal standards on appellate review in a restraining order case in California. Restrict your search to findlaw.com. Okay, so I've got 3 main elements in this prompt. Can anyone tell me what those elements are? How would you break this down into three fundamental elements? What's going on here? What am I really communicating to the AI?
I need to law about.
Yeah, okay. I need law about this thing. So my issue. What's my issue? My issue is the legal standards on appellate review in a restraining order case. What's the next element that I'm giving the AI?
Specific search for where you want it to come from, information.
Jurisdiction, California. Yeah, that's in there too. But the next thing is close,
Yeah.
right? Same thing. Jurisdiction, California. Do I want something from Minnesota? Do I want something from Washington, DC or wherever? No, I want something from California, right? And then what's the final thing I'm doing? Restrict your search to findlaw.com. So I'm saying only look here. Do I want you looking at some crackpot, like crazy lawyer's website who just like wrote whatever with his own AI? No, I don't want you to do that. I want you to go to findlaw.com. We can talk Thomson Reuters maintain database so that I know that you're looking at official cases and statutes. Okay, so you're giving the AI 3 things. You want your legal issue, you want your jurisdiction in the state of California, and findlaw.com. And again, are you going to just trust anything it says? No. Okay. All right. So then we'll do that. And what kind of response are we going to get? Let's see what it does. I have absolutely no idea what's going to happen here because, okay. So we have progress. All right. So this is what's called an agent or an early generation agent. It's got this pro search feature. So it's going to tell you actually what it's doing. It's unlike many other AIs that will just blurt out a response. It'll actually tell you what it's doing along the way. Huh?
I said I've never seen agents blurt out.
Yeah, they're even more advanced than this. If we have a minute, I'll show you some. I've asked questions. I'm very proud to say where it's thought for 99 seconds. And I'm like, well, didn't I just stump the AI? All right, so as you can see, it tells you what it's doing. It's searching it's doing what I asked it to do. And it's telling you where it's looking. So it is in fact restricting itself to California, hopefully, and findlaw.com, which is, the official database that I want it to stick to. Okay. And then what do we get? Okay, great. We get, we get an answer. So the difference between, so this is a search, it's accessing the internet. The difference between this and Google, and it does this for all sorts of things, but it's a useful thing for the law. Because it gives you an outline. Okay, so instead of giving you, like when you do a Google search, I mean, let's be honest these days, how useful is a Google search? Like, am I right? I'm like, I do a Google search, I'm like, I now know less than I did before I did the search. Like, what is this? Right? You know, so it'll give you like what it considers to be a reasoned overview, you know, it's organizing stuff. And then what do we have like here? Right? There's a little two. Can everyone see it? What do we have? Oh, it's a case. And you can click on that, and then it takes you to the actual case on findlaw.com. Okay. So when you're doing your legal research, you know, there you are, and oh, here's, you know, some more stuff. Is this accurate? I don't know. It's just for demonstration purposes only. Should you use this? No, not without verifying it. But this is what it gives you, an overview and specific footnotes with the cases that it's referencing. So if you have your own legal issue that you're putting in here, please educate me about the denial of child custody, you know, whatever the case is, whatever the issue is in California, then it's going to give you cases that are probably relevant to whatever search that you gave it. Again, you just click on it, it gives you a list, and you go and verify them. And so when you're going and working on your brief, in the law section, you remember, we had this section on the law. Now, all of a sudden, if you can verify that these cases exist, if they help your case, if they help your argument, now you know what to put in there. Okay, so the really interesting, crazy thing is that with this tool, with this tool, hold on a second, just get here. With this tool, when used properly, okay, you now have, believe it or not, you now have access to legal search and artificial intelligence that is just as good as any lawyer has. Just think about that for a minute. You now have access, if you use it right, to technology that puts you on a level playing field with lawyers. This is the first time in human history that access to justice has happened quite like that. So as a society, you know, we have some very, very big questions, you know, to think about. Okay. That doesn't mean that you can treat it as a lawyer. It doesn't mean that it is a lawyer. It's not, and you can't. Questions at the end. But all I'm saying is that the amount of intelligence that you have available to you is pretty substantial. Okay. And the important, if anyone does Chat GPT, this is an example of, they have O1 preview. Here's an example, thought for 10 seconds. It tells you like what it was thinking, right? Thought for 10 seconds tells you what it was thinking. Okay. So again, there are now, you know, when we were doing the perplexity one, it tells you what it was doing. We now have this new generation of models that are going to be checking themselves, checking their own answers. You know, when you select, you know, which of these tools to use, when you see that type of thing, you know, it is an indication of a slightly higher level of confidence because you know that it's running its answer through itself and thinking about it just like we do. Let's consider for a second. If someone asks you an important question, like an important question, not do you think it's going to rain tomorrow? But like, you know, I don't know, some really, really important question about a life decision. Are you going to like move to a different city? Are you going to get married? Or well, I don't know. These types of things that we do. Do you like answer? You think about it, right? And so that's what we do whenever we use these tools. And, you know, finally, I'll say, what is an example of the type of question that you can ask the AI to make sure that what it just said is correct? Anyone have any ideas? Okay, what are your sources? What about what I just said? Are you sure? let's see what happens. Are you sure? And then it'll give you, another answer, and you can compare that. So the point is, when you're doing these types of, researches, it's just the same as that we do as human beings, right? We say, okay, I found some information. Do I just take it at face value?
Still double
Maybe,
check.
maybe not. I'm going to check it. I'm going to think about it. I'm going to verify it. I'm going to get, so I'm going to try to get 3 different confirmations, like, this type of, and so it's not a, it's a new technology, but we're applying the same types of things that we already do. And so now say, okay, I want to, this is a good, say, for example, this is a good response. I'm going to copy it. And then I'm going to go over here to my other AI that has a writing feature called the canvas. And I'm going to say, please use this to help me draft an opening brief for an appeal. Use the canvas feature. Cut and paste it. And boom. Okay. Now we have it opening up a new document that you can work with here. It's writing it, going pretty fast, right? Writing a legal brief. You can select stuff here and say, you can ask another question about it. You can select it and say, for example, please simplify this. This is your chat over here in the left. It'll simplify it there. So you can work with your document here. So now you've got all of that going on. Say you want to attach the opening brief. You can just upload your documents that way. Okay, so you can literally take the upload feature. You remember that? That's you can say, for example, let's put this in there. I'm going to attach the this was the sample opening brief, right? Oh no, that's the wrong one. Hold on a second. It's my sample opening brief. Sample opening brief. Just download that. Okay. So this was my sample opening brief, if you guys remember, right? This is the one about Goldilocks and the 3 bears that I showed you. So say we're doing formatting and you say, you attach it. Now I'm, attaching it to say, okay, I want you to have a look at this and make our brief look like this one. Now all of a sudden, boom.
Oh my God. Where was that when I was
Okay. So this is not, going to be, this is just for demo purposes. So this is obviously not accurate. You're going to have to tinker with it. But the point is that the tools can now, see, and they can interact with different documents, and they can, so I hope, Joyce, I see some lights going on. I see some light bulbs lighting. What- Astronomical, isn't it wild? Yeah. So anyway, the point is that, this is just for demo purposes. So it's not producing an output that we can use in any way. You have to learn how to optimize the AI, work with it. But you see what I'm saying? We're going from, okay, this timeline, that you have, to these resources that you're putting together, to whatever research that you're doing, legal research, to the actual drafting of your brief. And you have, a super smart helper helping you out along the way. Okay, so hopefully, when you put all of those together, you go from an appealable order to the court opinion, and you have as many appointments with us at our clinic as you would like. We're here to provide human support whenever needed. And by the way, just on the step one, when we said where is the case appealable? Say you actually want to know, and you want to know, is there an exception? I have this order, is there an exception or something like that? Say you don't know whether it's appealable. What's maybe one of the first things that you do? You find out? That's not a bad idea. How do you find out?
Yeah, I see.
You ask the AI. Is this appealable? Give me some authority. You can upload documents and put it right in and get an initial opinion and start from there. Okay, so that's our presentation for today. Caitlin, if you want to stop the recording.